Mark?
I guess, you know, in terms of, this is sort of the vague proposal bordering on a notion. I would suggest that we not proceed with the LUPA, but rather that we extend an invitation to the county and the port at the earliest possible convenience to set up a meeting of the growth management steering committee. I would like to see that go forward sometime in the next, well within the next month, so that we can get on the table and we can begin to talk about these issues. And that's where I am right now.
Okay, thank you, Mark. George?
I would propose an amendment to that to accelerate the time frame so that the committee would meet no later than 2 weeks from today. The deadlines are still tight, even if we don't go with the tightest one. The next one will be coming along pretty fast, and if the meeting doesn't occur until a month from now, it'll be on us. It's incumbent upon us all of us, to meet together in good faith and to back away from the brink. If we can't do that, if we can't meet for a month, we're still at the brink, and I don't see any point in meeting. I'd suggest 2 weeks rather than a month.
Lori?
I totally support Mr. Welch, what you said, and I think you, again, spoke very eloquently. I understand what you're saying, George, that you wish to have this happen soon. I can support that if you are willing to say, I want this to happen as quickly as it possibly can, rather than the dictatorial addition of the statement, it must occur within X amount of days.
I don't know. I mean, if that's the will of my colleagues, I'll go along. I don't see why putting a 2-week time frame on the high road is some kind of crime. But
I said it was a crime. I said it was uncomfortable.
Okay, well, I'm not, but I'll defer to the rest of us.
We previously agreed to set aside a date for joint meetings with the county on Thursday.
I think what we said was each quarter, but we didn't set aside a date.
That's what my proposal is for the committee, actually.
Yeah, that's what I'm saying, substitute that night.
Well, I think we need to vote.
Let's keep going around and then we'll figure out what we're doing first before we start to assign dates. Chris?
I would agree that we need to do both as well. I don't think that our quarterly joint meeting should be replaced by the steering committee quite yet. I think there's plenty of other things we can collaborate on as a larger group, and I think it leaves the door open, as seems to be a popular statement. And I actually support 2 weeks. It's a lot of pressure. It's a very short timeline, but things need to happen, or we're going to be sitting there again at the last possible day, at the last possible second, having the same conversation. And in addition, there was 2 things that I thought somehow direct the staff to start the dialogue immediately, either in conjunction with this steering committee and or already have some ideas if they could meet. They're here, each day. Perhaps the staff involved in all of those 3 areas could meet immediately and start kind of laying some groundwork, perhaps. And the other one that I thought would be very important is to contact the county, and obviously they are very aware of what we're discussing, and if we agree not to file the LUPA, to have some sort of an agreement that they will not come back and say that was the proper way to go. That we are not filing this in good faith, and that they're agreeing that they can't come back and say, well, that was the way you had to go.
John, can I ask you just a procedural question in regard to this comment about the LUPA and the process? So If the city and the county could not, or the city, county, court, whatever, were unsuccessful in, and the city council felt it necessary to go ahead and file a joint growth management appeal, is it the county that comments, or is it in fact the joint growth management board that says you should have filed the LUPA first?
No, it would be, if and before the deadline to file the growth management appeal, which is approximately February 13th, it's 60 days from the date that the county adopted the ordinance on December 15th. If the city went ahead and filed the growth management appeal, then it would be either the county or the port who could assert a procedural defect in the city's challenge. And the procedural defect would be that the city should have and is required to file a Superior Court LUPA action, and the failure to file the Superior Court LUPA action renders the growth management appeal moot. I don't think that's a well-taken position, but it's a possible position that the county could take or the port could take, and if it prevails, then the city's growth management hearing board appeal would be struck down as being filed in the improper form, filed in the incorrect form.
So though the rezone was approved by the county, the port would still have the opportunity to weigh in regard to whether LUPA was the proper process?
Yes, they would be able to assert to the growth management hearing board that the action was a land use decision properly filed at Superior Court as opposed to a growth management hearing board issue properly filed before the growth management hearing board. So yes, either the city, either the county or the port could assert that the proper form was the Superior Court and not the growth management hearing board.
Thank you for that clarification. That sort of.
And just one further comment on Chris's comment. There really isn't any way to get a binding commitment from the county unless they are willing to give that to the city by mid-afternoon tomorrow, enter into a written stipulation that they wouldn't assert a failure to file a LUPA action as a grounds for dismissing a growth management hearing board appeal. If they didn't do that because they didn't have time to do it or whatever,